Good evening, everybody. We are approaching more and more the magic moment of starting our forum evening. Dear ladies and gentlemen, dear friends and supporters of the Goethe Hamburger Center for Advanced Study in the Humanities, Law as Culture. In Germany, as in many other European countries, migration and the recent move of refugees in particular has led to a rising number of child marriages. Not to speak of medieval times when young boys and girls of 3 and 4 years were married in aristocratic families. Girls are frequently married at a very early age, either before leaving their home countries or while fleeing. It is linked to the situation, what makes it not easy at all. This happens largely in accordance with the laws of their countries of origin. In Germany, however, child marriages cause, and this was the announcement as you have formulated it, legal conflicts, and how those conflicts will be resolved is the topic of our evening. On this evening, Professor Dr. Nina Dethloff, current Executive Director of the Goethe Hamburger Kolleg Law as Culture, will talk about the topic of child marriage among refugees and migrants. This phenomenon has led to the introduction of the, wie heißt es im Deutschen, Gesetz gegen so that means a bill to combat child marriages, which recently passed in the German Bundestag and will shortly be considered in the Bundesrat. In her lecture, Professor Dethloff will critically evaluate the current law as well as the proposed reform, taking into consideration diverging interests and guarantees. At stake is the protection against forced marriages and the safeguarding of the freedom to marry, as well as the recognition and protection of a potentially existing family life, including children already born out of the relationship. We have also to think about those children. While in an increasingly globalized world, different cultural traditions and concepts, as well as religious beliefs and legal norms, have to be taken into account and respected. Some values and norms are deemed to be accepted from particularistic recognition. Insofar, the topic touches one of the most central questions of the Center's project. That is, in how far culture may become a juristically valid argument in extending life and identity protections to other normative orders that, like judicial scapes, do not halt at the frontiers of the respective state formation. This has been the central topic of the 6th year of the first phase, having found no general solution to this general problematic, but remaining as a permanent challenge to balance between indispensable universalism and calculable particularism in the construction of normative orders in a global world. Family law is, for the sake of measuring where the societal debate is moving to, in this eternal debate, an excellent indicator. So, for example, Durkheim, I have to quote him, as you know, has written, La coutume exprime donc exactement la structure de la famille, ou plutôt, elle est cette structure elle-même. So that means that family law isn't and can be an indicator of societal evolutions, revolutions, and of ways to discuss how to live and how to construct one's personal life world. No need to say that for such a problematic, Nina Dethloff would be and is specifically qualified. She holds the chair, most of you know, but so if I'm repeating something you know, please be so kind to correct me afterwards if I made a mistake, or even during the debate, of course. Chair for Private Law, Private International Law, Comparative Law and European Private Law, Director of the Institute for German, European and International Family Law at the University of Bonn. You studied in Hamburg, Geneva, Freiburg, and you received at Georgetown University in Washington your LLM on a Fulbright scholarship. I'm very proud to have been also a Fulbrighter. In 1986 and 1987, she worked as consultant to the Federal Trade Commission, Washington, D.C., and was admitted to the New York bar in 1987 at Mexico City during a big conference. By the way, one of the nicest reception had been done by the New York bar. In 1991 or something, Nina Dethloff has received her doctorate degree at the University of Freiburg, where she subsequently completed her habilitation with the work, and this is interesting, about Europeanization of Competition Law, also Europäisierung des Wettbewerbsrechts jenseits der familienrechtlichen Spezialisierung. Since 2001, you research and teach at the University of Bonn, have been judge at the European Court of Human Rights, etc. I have to a little bit to be short, otherwise you don't have a chance then to make your talk. No wonder that you have published also extensively in comparative and international family law. From 2012 to 2013, you have been invited to become a fellow at the center, then afterwards deputy director and now current executive director of the center. So, among all the wonderful publications, I have to mention at least one. That is the Familienrechtsbuch with the editor Beck, because I was so proud that some 30 or nearly 40 years ago, I could discuss it with Professor Beitzke, who has, I think, invented this book, some of the first versions, very close to Catholic marriage ideas, projects, and legal ideas, but that have changed a little bit. We'll listen to your talk and we'll know, the floor is yours, what kind of changes have taken meanwhile, especially when we think that when looking at those crazy people who marry at this age, what is really horrible for us, that in the same time it would be the same Islamic legal cultures that look at Germany for the moment for same-sex marriages and thinking how crazy those people really are. And they think, not with the same arguments, but in the same line as our Chancellor is rejecting this idea. We have to be aware of such a complexity. So thank you very much for your attention, and the floor is yours.
Well, thank you so much for this kind introduction to my colleague and co-director and founder of the Center of the Law as Culture, Professor Werner Gebhardt. Ladies and gentlemen, hard cases make bad law. That is what a well-known legal phrase proclaims, meaning that to achieve justice in an individual case, and an especially difficult case, may not necessarily be a sound basis for a general rule or norm that is appropriate for the majority of cases. However, other scholars have argued, on the contrary, that hard cases make good law, because they illustrate that the general norm needs to be shaped in a way that allows to do justice also in difficult cases. Well, today I'm going to start by telling you the case, and then we will see about whether it's good or bad law. A 14-year-old girl and her 7 years older cousin, both nationals of Syria, were married shortly before fleeing from their home country. After their perilous journey, they ultimately arrived in Germany. And there they initially lived together. But after a while, the girl was placed under the guardianship of German youth authorities, who put her in a home for unaccompanied minor female refugees. A legal dispute arose whether they were authorized to do so or whether the girl could herself determine her place of residence, where she wanted to live. If a minor is validly married, the youth authorities' rights as a guardian are limited and do not encompass the right to determine the place of residence as well as having contact with her husband. Therefore, the legal issue in this case was whether the marriage was valid. In June 2016, with a girl meanwhile 15 and a half years old, the Higher Regional Court of Bamberg ruled that the marriage which was entered into in accordance with Syrian law was valid in Germany. At that time, the number of refugees, you remember, had reached almost 1 million. Consequently, this decision made the tabloids, was all in the headlines, and was widely considered to be bad law. Much along the lines, child marriage is now legalized in Germany. There was a public outcry and a heated debate ensued. Although the case was, and still is now, pending before the German Supreme Court, the Federal Minister of Justice followed this call for action, and in March this year, it all happened very quickly, a government bill to combat forced and child marriages was introduced, that you have already mentioned. The views on this bill widely diverge. On the one hand, urgent measures were deemed necessary, much in line with the purposes of the Canadian Zero Tolerance for Barbaric Cultural Practices Act, as the law against early and forced marriages in Canada was initially named. On the other hand, the bill has been harshly criticized as an act of legal colonialism. The German Bar Association argued that it showed a lack of respect for other states' legal systems, while deeming our own as superior. Meanwhile, the bill has passed also very quickly in the German Bundestag, the lower house of parliament, and will now be deliberated in the Bundesrat this coming Friday. Today in my presentation, I will consider how marriages with the participation of minors are and should be dealt with in a multicultural context, where diverging legal and religious norms have to be taken into consideration. First, I will give an overview of the tremendous normative diversity regarding the age of consent, and will also identify the reasons for the increasing incidence of those norms and legal of their clashing. And then, against this background, a closer look will be taken at the current legal situation in Germany, before I will then critically evaluate the reform. So, now let us begin by looking at the age of consent around the globe. In many Western, and in particular European countries, the age of consent has constantly been on the rise. You already mentioned the 11th, 12th century, where it was very low, but it has been rising constantly, but only recently up to this degree as it is now. Only decades only a few decades ago, the marriageable age was usually much lower than majority. Often it was lower for girls than for boys, and for them as low as 16 or even 15. Meanwhile, there is a clear trend towards setting the general age of consent for both sexes at majority. That is nowadays mostly at the age of 18. However, most European legal systems provide for exemptions and either allow marriage with parental consent or judicial authorization at a younger age, mostly at the age of 16, but sometimes even at the age of 15. Lately, more and more states have started to abolish those exceptions, though. For example, in Switzerland, but also now in Sweden, and since 2015 in the Netherlands, majority is invariably, that is, without any possibility of an exception, the marriageable age. Underlying this trend is the growing influence of human rights instruments. A number of international treaties are seeking to protect children and to guarantee the freedom to marry. The UN Convention on the Rights of the Child of 1989 explicitly stipulates the best interests of the child as a guiding principle. In all actions concerning children, whether undertaken by courts of law, administrative authorities, or legislative bodies, the best interests of the child shall be a primary consideration. Moreover, the UN Convention on Consent to Marriage, minimum age for marriage and registration of marriages of 1962, that much way back, seeks to assure the full and free consent of the parties. With regard to the considerable divergence of national laws, this UN Convention refrains from explicitly stating a specific minimum age, or to mandate that of majority. But in order to prevent forced marriages, it requires national legislation, the legislation of the individual states, to at least establish a minimum age for marriages, as marriages at an early age are often not the result of the girl's own free will. There is also ample evidence that child marriages negatively impact women's economic situation, as well as their physical and psychological well-being. A number of studies show that generally early marriages are linked with a high likelihood of poverty. They prevent women from obtaining any further education and thus the chance to pursue a profession, become financially independent, and also later potentially to free themselves from their marriages. Instead, early and multiple pregnancies pose substantial health risks. Young women are often deprived of any procreative choices. Forced and early marriages are also frequently coupled with domestic violence, leading to tremendous physical and emotional harm. Consequently, international human rights instruments increasingly seek to counteract marriages at an early age. Despite these trends in international treaties, and sometimes notwithstanding their ratification, there are many countries around the world where the age of consent is considerably lower. This is in particular the case in some sub-Saharan legal systems, as well as in a number of Middle and Southeast Asian countries, but also in several Latin American jurisdictions. Frequently, in issues of family law, those states provide for the respective personal law of the parties to apply. That is, for example, the Sunnite Islamic law or the Hindu law, depending on the religion of the parties. Therefore, the age of consent may vary within one country depending upon the religion or also tribal affiliation of the parties who want to get married. Other countries have adopted the religious laws of the majority of the population as state law, or merely referred to as the applicable state law. According to those norms in particular, girls are often allowed to marry, or one must say be married, at much lower ages than boys. The age of consent may be as low as 13 or 14 for girls and 15 or 16 for boys. Moreover, frequently exemptions from these general marriageable ages are possible. For instance, although in Syria, the country that we were concerned with in our case, the age of consent is in general 17 for women and 18 for men, relatively high. A girl from the age of 13 and a boy from 15 onwards may get married by the competent judge if he is convinced that the parties have reached the necessary physical maturity. That is the requirement for granting such an exemption under Syrian law. In most of the countries with low ages of consent, such exemptions do not require a court decision, as is the case in Syria. Instead, parental consent is sufficient. As a result of the prevailing patriarchal structures, this often merely entails the girl's father's consent. That is then enough. All in all, it is not rare to find minimum ages as low as 12 or even 9 years. And sometimes there are no statutory minimum ages at all. However, also in the United States, in many states, minors can, at least with parental consent, marry as young as 14 or even 13. And sometimes there too, there is no statutory minimum age at all. Consequently, in quite a number of cases, marriages are actually entered into well below the age of majority there. When we look at it worldwide, though, the totals of child marriages are astronomically high. In 2014, an estimated 720 million women were married before reaching the age of 18. 220 million even before their 15th birthday. This is not only due to the statutory framework, that is the legal norms pertaining to the age of consent, however, but it also results from the prevailing practices in the countries. Even in countries where the marriageable age, according to the law, has been raised, such as in India and Turkey, the tradition of child marriages often persists. This has a number of reasons. There may be no efficient registration in place, so that it simply doesn't work that way. Or the control of the marriageable ages may be inadequate. Also, often a marriage that was concluded in violation of the legal requirement of the specific age will never be annulled because such an annulment cannot be initiated by an official body, an administrative agency, or court, for example, but it requires a complaint either, for example, by the bride's parents or by the former minor, him or herself, and therefore it never then takes place. Persisting low marriageable ages are often resulting from a variety of cultural, religious, and social factors. The widespread tradition of the women's families receiving a so-called bride wealth, with the amount often decreasing as the bride gets older, provide a strong incentive to early marriage, in particular where the economic situation is bad. Conversely, the bride's family may traditionally have to pay a price as a dowry, which might rise with age or lack of virginity, thereby encouraging families to marry off their daughters early. At the same time, this shifts the economic burden of maintenance then to the groom and his family, another incentive to early marriage. Moreover, notions of family honor in case of premarital sexual relations may be considered to require an early marriage. This may be deemed necessary where a girl voluntarily entered into an intimate relationship with a boy or a man before marriage in violation of the prevailing cultural norms. However, it also often happens in cases of rape, where a young girl was raped and her family's honor is considered only to be restored by her getting married to the rapist. Lately, with a massive movement of refugees, other factors gain also an importance. Married girls are deemed to be better protected against the dangers of the flight, in particular from sexual violence in refugee camps. Now, globalization has led to increasing clashes of these diverging legal cultures. In the course of worldwide migration, couples are in many instances moving from one jurisdiction to another, where there exist vastly different legal norms concerning their marriageable ages. And lately, the movement of refugees in Europe and Germany in particular has led to a rise in the number of child brides and child marriages there too. Mostly the couples come, like in our case, from the Near East, Syria, Afghanistan, or Iraq. Whereas the figures may not be large, we had 1,475 at least officially documented married minors, mostly girls in Germany during the last year. The increase in this instant has been dramatic, and it has raised fundamental questions about the validity of child marriages in Germany. Now, before this background, let me now turn to the legal situation as it still is at present in Germany. I will start with the probably less problematic situations where couples intend to enter into a marriage in Germany, before then considering under what circumstances a marriage that has already been validly concluded in another country will subsequently be recognized in Germany. First of all, we have to remember that a marriage within Germany may only be validly entered into before a registrar, a Standesbeamter, whereas a religious marriage has no legal effect, no state law effect. The registrar examines whether the conditions for the conclusion of the marriage are fulfilled. And he examines, or she examines in particular, whether the relevant age of consent has been reached, and will refuse his or her participation in the marriage proceedings, the marriage ceremony, if they are not met. German law currently, as it still is, provides that a marriage should not be entered into before the parties reach the age of majority, that is, the age of 18. However, the family court, on application, may grant an exemption from this provision if the applicant has reached the age of 16 and his or her future spouse is of full age. At least one party shall have legal capacity. That's the reason. The grounds for granting such an exemption are not specified in the civil code, but there is case law, and that requires the courts to decide, after hearing the minor and taking in all information, and then decide having regard to the best interest of the child. That is the guiding principle both in German family law as I pointed out, according to the UN Convention on Children's Rights. However, when examining whether the age of consent has been reached, the registrar does not always apply German law. Rather, if a case has a connection with a foreign country, the question arises which of the vastly diverging laws concerning the age, the conditions for the marriage, the age of consent, for example, then the registrar has to apply. The general principle in Germany is that the conditions for the conclusion of marriages are, as regards each of the person engaged to be married, governed by the law of the country of which he or she is a national. This is the so-called nationality principle. Consequently, German nationals may nowadays enter into a marriage before reaching majority, under the conditions that I have just described. That is, if one is at least 16 and the other 18, and a family court grants this exemption. German law also currently applies to recognized refugees who reside in Germany. Conversely, in case of foreign nationals who intend to enter into a marriage in Germany, the respective foreign law determines the relevant age of consent. That is, an English couple, both 17 years old, may therefore get married before a German registrar because English law, the law of their nationality, allows them to do so. However, applying foreign law to the conditions of foreign nationals' marriages does not mean that no matter how low the respective foreign law has set this age of consent, foreign nationals at this young age, 13 or even younger, as I described what laws of other countries there are, that they are actually allowed to enter into marriage in Germany. Because there are limits to the application of foreign law. In general, a provision of the law of another country shall not be applied where its application would lead to a result which is manifestly incompatible with the fundamental principles of German law. And what does that mean? This so-called public policy exception precludes the application of a foreign norm if this application would violate fundamental rights, notably the German Constitution, our basic law. The German Grundgesetz guarantees the freedom to marry, Article 6 of the basic law, which has been in a public discussion, protection of marriage, and what does that mean? Does that mean also protection of marriage, same-sex marriages? But also whether for same-sex couples or not, it protects the freedom to marry. And I would argue for both same-sex and heterosexual couples. But that is set aside. So it guarantees the freedom to marriage. And that means to enter into this marriage by your own free will. So that is one of the fundamental principles. And also, the German basic law guarantees the child's fundamental right to free development of his or her personality. That is also enshrined in our constitution, and that means that the best interest of a child is to be protected, and he is or she is free to make his or her own decisions. Both require a child to be protected against any acts that have consequences that he or she at that moment cannot foresee. So what does that mean for the application of foreign law as regards the age of consent? Currently, German law itself provides for exceptions, as I have told you, from the age of majority. Therefore, at present, no violation could be found if the foreign parties are at least 16 years old and where a comparable judicial scrutiny would take place concerning the freedom of the will of the parties, it's the best interests of the child. as currently the judges are required to do according to German law. But below the age of 16, the outcome appears less clear currently. I would argue that a German registrar should currently refuse to apply foreign law as violating fundamental rights if this foreign law allows the foreign nationals to enter into a marriage below the age of 16. But scholars in this respect are divided. Now, we have had a look at the situation, the conclusion of the marriage in Germany, where either German law applies to German nationals or foreign law applies to the foreign nationals with those limits. What about the situation where the marriage has already been concluded in another country and in accordance with the laws of that state, as was the case with our Syrian couple? Do the same rules apply there? The question of the recognition of a marriage in Germany may arise in different contexts and often a long time later. Rights and obligations under the marriage may be in dispute, as well as the parentage of children, or a petition for divorce, or also post-divorce financial relief may be sought. Without being validly married, no claims for maintenance may be made. The validity may also have to be determined in the context of immigration or deportation issues, where family reunification or the protection of family life is relevant. Whether the public policy exception precludes the recognition of the marriage in such cases, therefore requires a different consideration from the situation, those considerations that had to be made with a marriage to be concluded in Germany. The ages of the parties that were relevant when it was the question of the public policy exception within Germany, when the registrar should be allowed to apply the foreign law, those ages of the parties at the time of the marriage is merely one factor and not even a decisive one. Important others are, in particular, how much time has passed since, whether they continue to live together, have children, and what the consequences of the refusal to recognize would be for them. Those consequences might in fact be quite severe. Children born out of the marriage will not automatically be recognized as those of the husband. Therefore, a paternity action will have to be brought before they can claim any maintenance. Also, many years later, the wife may be refused a divorce and consequently any support. And if only one member of the family, or not the entire family, has yet come to Germany, the remaining members might not be able to enter or permanently reside here, even though they have lived together in their home country for a long time. Consequently, at present, according to the current law, in each individual case, a careful analysis of all the relevant factors is undertaken in order to determine if a marriage concluded abroad, according to the applicable law, validly concluded there, should be recognized within Germany. Therefore, no clear age limit has been established in case law, even where the age was below 16. While this leads to some uncertainty and, of course, a lack of predictability of the outcome, it gives the court sufficient flexibility. This, in fact, allowed the Court of Bamberg, that I had cited, to consider the individual circumstances of this particular couple and ultimately hold the marriage valid. Although the girl had, at the time, at least at the time of the conclusion of the marriage, not yet reached the age of 16. which then this decision in turn led to the current bill that I will now turn to. As mentioned, this bill has already passed the Bundestag and will now be considered in the Bundesrat. Since for this specific law an approval of the upper house, the Bundesrat, is not required, the Bundesrat could only call for the intervention of the conciliation committee, which I consider as very unlikely. The bill, this is what we will have in a couple of months then as the future law, I would predict. The bill proposes that in order to protect children, the age for marriage would be raised to majority without any exception. According to the bill, a marriage entered into before majority is void if one of the spouses had not yet reached the age of 16 at the time of the marriage. Void meaning having no consequences, no legal consequences at all. If one of the spouses was 16 but under the age of 18, the marriage is not automatically void of any legal consequences, but may be annulled. And this annulment requires a judicial decree, a decision by the court. However, according to the new law, the annulment must be effected. It's mandatory unless, first, the minor spouse has meanwhile reached the age of majority and has indicated that he or she wants to continue the marriage. Or secondly, unless, now that's important, otherwise extraordinary circumstances will result in a substantial hardship for the minor. Important to note is that the bill provides that these principles shall not only, and that is entirely new, not only govern in case of German nationals, where, as I have pointed out, German law applies to the requirements for entering into a marriage. This new concept, with a marriage age, invariably it's at 18 and void, marriage void below 16, and in between annullable. This new concept applies to the requirements for entering, applies also in general, where otherwise foreign law applies to the conditions for marrying due to the spouse's foreign nationality. This shall always be the case if the marriage is to be concluded within Germany. Therefore, regardless of the spouse's nationality or their status as refugees, within Germany, no marriage below the age of majority could ever be entered into before a registrar. Moreover, in order to prevent circumventions by resorting to religious marriages within Germany, minors shall not be allowed to enter into a religious or a traditional marriage instead or prior to the mandatory civil marriage. This prohibition is directed at the wedding person, also at the holder of the parental responsibilities, that is the parents, and any witnesses, but not directed at the minor or him or herself. And a violation shall constitute an administrative offense. So there here the legislator wants to make sure that this is really not, no circumventions are taking place. So that religious marriages are entered into, but below the age, the marriageable age of 18, that have no legal effect then in state law. Now, in the case of a marriage by foreign nationals, validly concluded abroad, that was the other situation. They remain valid only if continued until the minor has reached majority and neither of the spouses have lived in Germany between marriage and reaching majority. Then it all happened in the past. In all other cases, according to the applicable foreign law, validly concluded marriage shall either be void if entered into below the age of 16, or annullable pursuant to the aforementioned principles. So, what does that mean in the case of our Syrian couple? In this case, the marriage would thus be considered null and void, because the girl was at the time of the marriage below 16. And this would even be the case if the girl subsequently, they lived here and they subsequently reached majority and they have continued to live together and wanted to do so. They would have to remarry in Germany. However, if they omit doing so, assuming, for example, that they are already validly married, especially the financially weaker, often the woman would lose any protection in case of separation. Here, negating any consequences or negating the existence of a marriage might result in a hardship just for those who are sought to be protected by the new law, because it completely disregards any existing family life. Here, a case-by-case judicial review might be more appropriate to recognize relationships that have formed over time and their consequences. Such a review would, however, have to be shaped in a way which effectively safeguards against forced marriages, or marriages that are not really founded on the free will of both parties. So, for example, where one party is still a minor, this would exclude the parents as representatives to avoid undue influence, because it might also be the case that they try to impose their views. So, in our case with the Syrian couple, this marriage, according to the new law, would be void of any legal consequences. And what would be the consequences of the new law if the Syrian girl had, at the time of the marriage, been 16 or 17 years old and then fled to Germany? Would the reform improve the situation in that instance? The marriage would not be void, but merely voidable or annullable by a judicial act, by a court decision. However, as the law provides, the court is obliged to annul it unless, as I quoted, otherwise extraordinary circumstances will result in a substantial hardship for the minor. Therefore, it would surely no longer suffice that the couple convincingly states before the court that they love each other. That was what happened in the decision of the OLG Bamberg, the High Original Court of Bamberg. They really wanted to stay together, and convincingly, obviously, I wasn't there, but the judges were convinced that they loved each other, and they were also convinced that the best interests of the child were sufficiently protected. That is, that the young girl, who was at that time 15 and a half years old, was able to recognize the consequences, what it really means to be married. So the question, that would not be enough. What would then constitute extraordinary circumstances resulting in substantial hardship that would exceptionally lead to the recognition of the marriage that has been concluded abroad validly? Now we'll take a look at the explanatory notes of the bill, and they merely cite the danger of suicide as a result of a refusal to recognize the marriage. And this would indeed be an extreme and exceptional situation. But one has to wonder whether other factors could not also substantially affect the well-being of the minor party or parties, and thus justify recognizing the marriage. Could it not be sufficient maybe that one of the parties is threatened by deportation? Or is this meanwhile no longer the exception but becoming the rule? Here, more questions than answers posed by this bill. Now, Coming to a close, my initial question might thus be answered as in the following. Hard cases make good and bad law. The case prompted the passing of a bill whose aims are certainly to be applauded, whose proposed means, however, fall short in some respects at least. First, raising the marriageable age without any exception to majority in German law is a well-founded, and I would say, and I have already argued that a long time ago, an overdue step. We are protecting minors from a variety of entering into contracts and from a variety of acts, but this one of the most fundamental contracts, entering into marriage, they are allowed to do before they are 18. So I would argue that that is a good step to be done. So, and also that this principle should apply as the bill foresees it in all cases of marriages to be concluded within Germany, regardless of the party's nationality and the generally applicable law. That is also to foreign nationals who want to marry here. Here, to adhere to the old principle, when in Rome, do as the Romans do, is not an expression of cultural imperialism. Instead, I would say it serves to further integration and prevent the persistence of cultural practices that pressure young women living in Germany to conform to traditional roles, precluding them from making use of the chances in their new home countries. On the other hand, with marriages celebrated abroad, the existence of diverging cultural traditions, of religious beliefs and legal norms has to be taken into account. They have shaped existing family relationships which need to be recognized. Here, the bill appears too rigid and lacks the necessary flexibility to protect the most vulnerable in our society, children and women who have been married as children. Whereas in some cases, they may need protection against marriage, in others, they need to be protected precisely by marriage laws. Thank you very much.